I'm going to introduce the final panel of the day on the intersection between IP and antitrust standards and standard essential patents. So this panel discusses the evolving issues at the intersection of two bodies of law that are very often viewed at odds with one another, both IP and antitrust. And nowhere is this more apparent than the antitrust regulation of intellectual property rights that are contributed to voluntary industry standards. Please join me in welcoming as panelists Mr. Alan Devlin, Acting Deputy Director of the Bureau of Competition at the United States Federal Trade Commission and former Attorney Advisor to Commissioner Maureen Olhausen. Judge Douglas Ginsburg, Senior Circuit Judge at the United States Court of Appeals for the D.C. Circuit. Aviv Naveau, Professor at the University of Pennsylvania and former Chief Economist at the United States Department of Justice. Mr. John Talladay, Co-Chair of the Antitrust Practice at the Baker Botts Law Firm. And the moderator, Ms. Corinne Wong-Irvin, Director of the Global Antitrust Institute and Adjunct Professor of Law at the Antonin Scalia Law School at George Mason University.
So we're going to try to keep this interactive, and we'll welcome you by show of hands to join our discussion as we talk about 5 topics. So the topics we're going to cover are first, standard essential patents and market power. So we'll talk about how to define a relevant market, how to determine market power. We'll talk about refusals to license at the component level in particular. We'll talk about tying and bundling standard essential patents and non-standard essential patents. We'll talk about extra jurisdictional remedies, which Josh mentioned in his speech. And then we'll talk about seeking or enforcing injunctive relief. So with that, I'm going to jump right in. And like I mentioned, we have 5 topics, so I'm going to keep the time for each topic, but we'll invite you to raise your hand and join in after each lead discussant gives some thoughts on each topic. So with respect to market power, there's a lot of confusion around the world about how to define a relevant market when it comes to standard essential patents. I've had conversations with some members of the U.S. antitrust agencies in which they say that SEPs will generally, although not always, confer market power unless there's a substitute standard, for example. And then you have approaches such as the Korea Fair Trade Commission in its recent decision against Qualcomm, in which it took what I view as an extreme and erroneous position of viewing every standard essential patent as its own market and saying, therefore, each standard essential patent holder necessarily has market power. And so, Alan, I want to turn to you first. If you could share with us, what's the U.S. approach on this from the courts, from the agencies, and how do you think the approach should be conducted?
Corinne, thank you so much for the kind introduction and for an excellent overview of the topics ahead. It's a pleasure to meet all of you. I'll get the necessary disclaimer out of the way, which is that the views are mine alone and not necessarily those of anyone else in the Commission. So, of course, market power, market definition, the two are caught up together, a threshold and most important inquiry. And I fear that there's been a tremendous amount of, if not uncertainty, I think there's been some of that. I think there's been some misconceptions about the proper roles those inquiries take in the high-tech field. So bear with me, if you will, while I just back up a little bit from the whole SEP issue and just ask a more basic question, which is, what are we trying to get at when we define a market and look for market power? The answer, of course, is the ability to essentially affect market outcomes for a sustained period, because without that power, there's nothing to be concerned about from an antitrust perspective. The only exception we make to that, of course, is in cases of per se legality, where the type 1 error cost potential is essentially 0. Now, on the area of patents, most patents, of course, as economists have long known, confer little or no market power of any kind because there are no lack of substitutes, both on the demand and supply side for the provision. Eventually, the Supreme Court caught up with what the rest of us all knew in Illinois Tool Works, so that remains the law of the land. So the question is there something particularly special about SEPs? Well, the answer is, of course, maybe, because we define markets by reference to substitute and supply alternatives. And much of what we've seen in the standard essential space is infused with a powerful theory and narrative that's caught hold, which is of course hold up. And I think we could speak for the whole panel about nothing else. I don't want to go down that rabbit hole. It's beyond to say that what we have, I think, is a possibility of market definition around a patent embedded in a standard, but only on conditions that have to be fulfilled in practice based on the evidence at hand. Bear in mind that patents, as Mark Lemley has written about and others as well, are probabilistic rights to exclude. It's hard to see how one has monopoly power over an invalid SEP, and the fact that you have a declared SEP or announced SEP does not in fact actually mean it's a valid right that will exclude successfully from the market. We've seen questions about that, if not ignored, downplayed, and I think that can be a mistake. Now, that's not to say, of course, that issues go into an absence of choice in a standard in which a company or an industry has invested is irrelevant, and there may well be plausible markets limited to the technologies, proprietary technologies embedded in a standard, and Broadcom versus Qualcomm in 2007, per the Third Circuit, told us that. But when we take a step back and we look more closely, I think you'll find that an appropriate level of economic rigor and respect for the evidence and facts at hand are what would characterize at least the FTC under now acting Chairman Oldhausen's leadership. And I think what we've seen in some somewhat prosaic approaches to the questions, threshold important questions in the SEP space, will be approached with a more empirical focus going forward. Thank you. I look forward to hearing what my co-panelists may have to say.
So I have some follow-up questions, but any thoughts from our other panelists on SEPs and market power? So one of my questions is, Dr. Anne-Lane Farrar, who's here, and I have written and talked about how, and the importance of needing to apply a regular market definition and market power analysis to SEPs, to not treat SEPs differently, but that also that SEPs might be, because standard essential patents are perfect complements, it might mitigate any market power. Does any of the panelists have any thoughts about that, and about, we heard on the last panel about superior bargaining position, and we heard earlier in the day from Dr. Padilla about bargaining power. Where does, the implementer's ability to push back in negotiations come in here, and what does this have to do with market power, if anything?
So maybe I'll just jump in for a moment. If you look at the traditional definitions of market power, it's the ability to control prices and exclude competitors. And sure, there may be some standards that don't have adequate substitutes and can confer market power, but one would think it's the standard that controls the market power, not necessarily each SEP within the standard. But I find it kind of interesting because by virtue of being a SEP, right, it's encumbered by a FRAND commitment. And so to disassemble the concept and say, well, we're going to recognize the market power that comes from being a SEP and being part of the standard, but we're going to ignore the FRAND commitment, which essentially controls for the two factors that confer market power, pricing and exclusion, right? Because the two aspects of FRAND are the access right, which means competitors, at least as to that version of the standard, are not excluded, and the reasonable royalty rate, which essentially takes away the ability to control prices. So I don't know how you can recognize one aspect of that and say, yes, there necessarily is a market power concept here, without acknowledging the other and at least balancing those two in a given situation.
I think that's the most astute observation, to which I'd add just one thing, which is that it is possible to have a non-FRAND encumbered SEP. And I believe the Federal Circuit in 2015 talked about that. C0, I believe, is the case versus Cisco. It raises very interesting questions about, in any case, are you entitled to anything more than a reasonable royalty? So what, if anything, does a RAND commitment do beyond potentially foreclosing injunctive relief? As I said, we could, I'm sure, fill the hour with this alone, but I think I've said enough, but happily say more.
So I'll jump in and say probably something you've never heard an economist say, which is to say, why do we bother defining markets? I'm sure you've heard this before. And this does go to kind of where you sort of started, of saying, at the end of the day, I think there's times when we kind of let the checklist or some procedural get in front of what we're actually trying to say. And generally, I think defining markets, any Section 2 case, is very difficult for a variety of reasons that we all know. Might be even more difficult here. So maybe the thing to do is to say, maybe not get caught up in just, checking off some checklist, and saying we need to define market because we need to define markets, but instead ask, what is the harm? What is it we're thinking about? What are the empirical evidence for harm? What is our theory of harm? And let me kind of tie back to where you said at the end, where you're saying, currently the FTC, you kind of see them as going in that goal. I think that's, that's great, and hopefully you can live up to that standard.
Well, thank you for that. If you don't mind my pointing one more time. I think part of the problem is, well, I want to make a couple of points. The first is that the market definition question, as economists will tell you, is that you're trying to get some insight into the price elasticity of demand facing the relevant firm at the competitive price point, for which market definition is just a proxy and an imperfect one at that. As Richard Posner observed in his 2001 Antitrust law book, practically every firm in every market in the economy has some level of market power in a measure completely immaterial to antitrust policy. When we're talking about SEPs, I think the biggest mistake that sometimes happens is people define markets purely in a kind of after-the-fact way, looking only at the standard as it has been implemented rather than the ex-ante universe of alternatives. And it depends what it is you're trying to get at. If you're trying to observe what kind of anti-competitive conduct led to the creation of market power, it's important in the market definition to focus on where there was an elimination of a constraint formed by a substitute technology. So if you define the relevant market as the universe of alternatives, and then you can tie, for example, some deception by a potential SEP holder to acquire the inclusion in the standard, thereby eliminating alternatives, what you've done by correctly defining the market in a broader sense is focused in on what the core anti-competitive conduct is. By conversely, I think a mistake that the FTC in years past has fallen prey to has been to look at a market potentially in this kind of after-the-fact setting whereby monopolies are everywhere, and if you have a monopoly, you're only one step away from an antitrust problem, or if you have a standalone Section 5, maybe you don't have to go much further than that alone.
I mean, I think in the U.S., I'd like to hear comments about in the U.S., looking at effects, we can do that. We can jump right there. But in other countries, can you, does that seem like a possibility, or do they need to focus on dominance first, and then is there an effects-based analysis always?
Yeah, so I agree with everything Aviv said, except for where he said we shouldn't define markets. But I think it's especially important when you get to foreign jurisdictions. You need to walk before you run. It's not that lawyers are incapable of thinking about or analyzing effects, but it requires a framework, and especially in jurisdictions that are less experienced than the U.S. jurisdiction and don't have 100 years plus of enforcement experience, it's important for them to think about it within a legitimate, appropriate framework, and I think market definition is that framework.
So as I said, I want this to be an interactive with the audience, so we have about 4 more minutes left on this topic before we move on to refusals to license. Anyone from the audience have any thoughts on standard essential patents and market powers, or any questions for the panelists?
We've convinced our audience.
All right, well, we'll move on, and then you can have more time for a discussion of other topics. So the next topic is refusals to license. So in the United States and in India, there's been court decisions that really recognize the standard industry practice of licensing at the end user device level. But there's been much discussion about whether the refusal to license at a component level could be a possible antitrust or unfair methods of competition violation under the FTC's Section 5 Act. So, Professor Nouveau, if I could turn to you, what should be or is the appropriate analysis in the U.S.?
Thank you. I assume I have the extra time from the first panel? Good, thank you. So like Alan, I'd like to thank you for having me on this panel, and like him, I'd like to stress my views do not represent those of the FTC for obvious reasons. Okay, more seriously. So before I think kind of driving into details, what's the appropriate analysis, I think there's a couple of things that are important to remind ourselves. One is a point that I think took me as an economist actually a while to get into, and maybe, for folks in the room that are kind of experienced in IP, it's obvious, but I just want to sort of remind it, which is when we talk about, a refusal to grant a license, we usually talk about a refusal to grant an exhaustive license. And often when you hear the discussion, and me again as an economist and outside, I didn't realize there's actually a distinction between an exhaustive license and an ability to use the technology. Because when you hear the discussion is about, well, we're foreclosed, we're excluded from using technology. And that's very different than the not granting an exhaustive license. And that's going to be important when we kind of take this to the economics and think about the effect. And I just wanted to kind of mention that up front. In this area, I ask what's the appropriate analysis. And maybe before jumping to the appropriate, let me actually talk a little bit about some of the inappropriate analysis. And actually, in this particular area, I find some of the arguments that are made not just inappropriate, but downright silly. And it's embarrassing when you actually hear, silly arguments made by very, very smart people. So let me just kind of mention a few before I kind of go to what I think are kind of the real issues that the one that should be discussed. So often you hear arguments that are made, why should we see licensing at the component level as opposed to device level? You'd hear something as silly as saying, well, if it's at the component level, you take the same percentage as by a smaller base, and you'll get a smaller number. Okay? I mean, the first time I heard that, I was like, double take, really? If you decrease one number, you can increase the other and get the same outcome? I mean, that's, I don't know, my 7th grade daughter knows that, right? So they'll say, well, no. It's not quite as simple as that. Yes, that's the math thing, and you're the math guy, but that's not how it works. Okay? How it works is we have to present this to a jury. Right? And a jury, there's a limit on how much they can put. So, yeah, they maybe adjust the rate a little bit, but not all the way. Okay? And this is an argument I heard actually from a very smart antitrust guy. I'm not going to name him, but one of my predecessors at the DOJ made this argument. And to me, again, you kind of look like, it doesn't smell right, for a variety of reasons, if only for the fact that are we going to start bringing kind of behavioral models of jury behavior or whatever court behavior? I've never seen that anywhere in antitrust. So this is the area we're going to bring that in. So ultimately, it's really just about a disguise of saying, for whatever reason you think the rate is too high and device level, right? You're not going to make that argument directly, so you're going to go indirectly and say, this is our way to lower the rate. Okay, well, if the rate's too high, it's too high. Then, that's a violation of FRAND. You should take that head on. It's not about let's kind of go on through kind of this, roundabout way of getting it at. That's not kind of the argument to make, this sort of, kind of a behavioral type story, behavioral economics type story that we never use anywhere in antitrust, and suddenly this is the place where it'd be introduced. Okay, next thing we know, we'll say, this merger, yeah, there's a huge increase in concentration, but, don't worry because, they're good guys, they're going to behave well, they're not going to increase prices, That's the type of analysis we're going to do. So if we're going to resort to behavioral economics type arguments, we better have, cross our T's and dots our I's and do it rigorously. So that's just in terms of the type of arguments that there are many other arguments that I could go through, but, even with the extra time I make, I'm probably going to be over. So let me actually go to what is, I think, kind of the key issues and what should really be the appropriate framework. So I think the appropriate frame to look at, and it's very important, is to look at the issue of transaction cost. In academia, where I come from, you can actually say, all right, A and B are going to agree, they're going to agree on a patent, and, they're going to fight back and forth, and they're going to make it happen. Okay, you basically snap your fingers, and it's done. Well, when I snap my fingers, nothing done. Maybe when Judge Ginsburg snapped his fingers, it happens, but it takes a while until it gets to the judge, right? And we all know all these negotiations are extremely complicated, and there's real costs involved. Okay? So transaction costs, often people say, well, those are not real costs, right? Well, they are. Okay? Anyone who sat at a negotiating table know that these are real costs and have to be taken into account. It's been recognized on the academic level as well. Just a fairly recent Nobel Prize winner, Oliver Williamson, my ex-colleague from Berkeley, won it on exactly these types of issues. Okay, won the prize on exactly these. So these are real costs recognized by economics and should be taken into account. Now, why is that relevant kind of thinking about this component level versus device level? We have to realize, in reality, if we're talking about component level versus, it's not really component level versus device level, because if we're going to introduce at the component level, there's still going to be some licensing at the device level. So it's not component versus device. It's really multi-level versus device, right? So if you're going to have any sort of licensing at the component level, you're going to have to do it also at the device level. And that's going to increase industry-wide transaction costs and really kind of reduce the efficiency of the industry. And why is it going to increase the efficiency costs? For a variety of reasons. First, just the sheer numbers. there's just going to be more negotiations happening, right? Because you have to have it both at the component and at the device. Okay, but that's just the start of it. It's actually each of the negotiations, so even if the sheer numbers don't increase that much, each of the negotiations are going to be extremely more complex, right? Because if now you're negotiating with John and you're negotiating with me, we each have the incentive to say, no, no, I'm not paying for that. That's on John. And John is going to say the opposite. I'm not paying for that. That's on Aviv, right? So we're going to kind of point fingers at each other, and good luck pinning any of us down, either one of us down. And some of it could just be sheer strategy. That, you know, it's the incentives, even if we don't believe it. But some of it is true that some of the value that's generated by the SEPs is not, you can't just sort of say, this generates value here and that's exactly how much it is, and that generates value here in this component. There's a lot of complementarities, right? If you have, you know, a faster phone, you might actually more enjoy your photos a lot more, right? And those complementarities, the question is, at what level should they be paid, even if John and I are not being strategic at all? All right? I don't know about John, but I'm never going to be strategic, right? So you know that. So the question, even at that point, how do you assign the value? And that's going to really create real costs and real issues. And to me, those are the real issues that we should be discussing as to at which level are we going to get more efficient outcomes. And most likely than not, I actually believe it's going to be at the device level and not necessarily at kind of the multi-level licensing, although theoretically it could be in either one. But those are the issues and discussions that we should be having.
So just to take a step back for those of you in the room that are not antitrust lawyers, in the U.S. we generally treat refusals to license with a pretty much near absolute immunity approach. You know, the Federal Circuit in Xerox and Kodak, the court said that there's a presumption of validity. There's a presumption that it's okay to exercise your core right to exclude.
I'm saying a refusal to license is not an exercise of exclusion. A refusal to license, for example, a chipset manufacturer just means I'm going to make those licenses available somewhere else. You're free to go on and carry on with your business. That's the practical effect of it. So I think it's important to say that it's not really a refusal to license. It's a choice of where do I do my licensing.
I was just trying to add to what Aviv said, that it's doubly peculiar to see suggestions that licensing has to take place at a component level in an area where industry practice has settled on device level licensing. Presumably, the industry is interested in minimizing transaction costs and facilitating transactions, and to upset that would seem to me to be perverse unless there's an extraordinary reason.
I also commend everyone. There's a wonderful paper by Dr. Padilla that talks about, end user licensing or ad valorem royalties and the welfare effects of them, and that it actually can result in lower overall prices. Correct me if I'm getting this wrong, and spur innovation, particularly upstream. Yes, there was a couple questions.
Thanks. Thanks for the comments. So, in talking about the level at which you license, there are really two questions embedded in that, right? And it seems like in panels like this, we sort of conflate the two. And so, there's this question about whether there's an antitrust violation, and I tend to agree that antitrust isn't really the right question to ask here. But that doesn't mean that under the FRAND commitment, it's permissible. Right, it was a contractual commitment permissible to license at any level. And that's really just a question of contractual interpretation and asking the SDO or finding out what the SDO wanted. And, to Judge Ginsburg's point, I mean, some SDOs have written into their policies whether it's okay and they're under the non-discrimination prong of FRAND to license at different levels or to license, at every comer. And so it would seem to me that rather than focusing on this antitrust debate, which I think is really just a sideshow, the job of people, if it's really most efficient and so forth, as Aviv described, to license at the device level, quite possibly it is. Well, then the SDO should just clarify that in their policies, and it's a job of the members to convince the SDOs to make their policies clearer, to state what the intention is, because I think it really is a contractual question as opposed to an antitrust question.
The SDO is a voluntary organization and may represent people with firms with very different interests and perspectives. And so you see a variety of of requirements, sometimes a complete absence of a FRAND or RAND requirement. And it may well be that there simply isn't they can't reach a consensus on the point, and so they're not going to clarify it. Just like any other contractual, or for that matter, legislative process. So it's nice when it happens, but you can't count on it.
And I agree with that comment. This question doesn't come up in antitrust law. It doesn't come up in IP law. It arises out of the SSO process. And the real question is, does a FRAND commitment to license an SEP, is that equivalent to a requirement to exhaust your patent rights upon request? That's sort of the question. And again, it's not an antitrust question or a patent question. I think the only antitrust question would be, does a policy to license only to end users result in the exclusion of competition? Because without exclusion, you don't have an antitrust violation. And maybe there's a scenario there where you are seeking to exclude at the component level, but refusing to license, where you could have that kind of exclusion. But the last time I checked, the right to enforce a patent it requires active involvement, not passive involvement. So you could almost sum this whole thing up by asking, if an SEP falls in the forest and there's no one there to enforce it, is there any exclusion?
I thought I'd add in just one thing, which is my conspicuous silence on this topic. Unfortunately, my current role in the front office of the FTC, I'm somewhat constrained on this particular issue because a pending matter may or may not involve questions akin to these, such as the nature of the job, unfortunately.
And I'll just say real quick, and correct me if I'm wrong, to the question about SDO policies. I think the only policy that actually most policies, like the Etsy policy, I think requires licensing to at the end user device level to fully compliant implementations, and it's really only the very controversial IEEE policy that requires licensing at the component level.
Right. I think astutely observed. One thing I think I can fruitfully point out is that the acting chairman of the FTC does not support, and adamantly does not support, a theory that a breach of contract is standalone Section 5 unfair method of competition or otherwise an antitrust violation divorced from anything else. So to the extent we're looking for any kind of certainty in a world which is lacking much of it right now, that's at least something I can provide you with.
My question to the panel is whether there's something much more fundamental here, because the question as to whether the licensing has to take place at the component level or at the device level, or whether there should be an injunction or not, is something which a judge hearing a patent infringement action has to decide. How would it trigger a competition authority to go into it even before a trial has happened or even before a suit is decided? Doesn't it constitute an intrusion into the powers of the courts? And hence, I think a kind of an arm-twisting mechanism for the implementer to kind of say, okay, you sue me, I take you to the competition authority. So there is an intrusion here into the courts and to the judicial independence here. And I think, therefore, in the context of SEPs, for which there is no separate statutory provisions in most statutes, I think the fact that competition authorities are coming in such a nascent stage of the discussions or the negotiations itself proves to be a deterrent to patent owners. What would Judge Ginsburg and John think about this?
Well, in an administrative system such as we have with the FTC or most agencies around the world have, where the agency issues an initial complaint, subject to if it finds an infringement, subject to judicial review, it's quite ordinary for the agency to make that determination initially. It doesn't invade the province of the court. It would be peculiar if in a judicial system such as with the Department of Justice going into court, for them to do something prior to going into court other than make their allegations would admittedly be peculiar, but that doesn't happen.
I think, correct me if I'm wrong, you're referring to the 5 Delhi High Court decisions where there was, involving Ericsson, where I think Ericsson went to the court first to resolve the dispute, and then some of the implementers complained to the competition agency to try to get the agency to intervene. And the court said, let us finish what we're doing first. Let us finish the dispute here. And the court said that end-user device licensing is a norm. Non-disclosure agreements are norms. form. They and actually, I think, issued several interim injunctions on standard essential patents. So in the interest of time, we're going to move on to the next topic. Our next topic is tying and bundling, which is another, a very highly discussed issue, the issue of portfolio licensing or tying and bundling standard essential patents and non-standard essential patents. And Alan, I'm going to turn it back over to you to lead us off.
Thank you again. I'm going to try to be reasonably quick to keep things moving along because happy hour is fast approaching and I know where interests lie. So the fascinating world of package licensing and bundling of IP rights. There used to be a day in which the concept of monopoly leverage loomed large over patent law itself through the patent misuse doctrine, motion pictures, etc., and indeed for a time in antitrust itself. Thankfully, that era is somewhat behind us today. I think most economists looking at the economic effects of bundling IP rights would be hard-pressed to see how bringing non-essential patents into a package portfolio license along with essential patents necessarily causes issues. But you don't really have to take my word for it. There's a more important institution there, which is the Federal Circuit in 2005. And Phillips explained quite nicely in a patent misuse holding why package licensing of essential and non-essential patents doesn't necessarily amount to misuse. One might observe, well, hold on, that's patent misuse, it's not antitrust. And indeed that's true, but under the rule of reason approach that the court employed to understanding misuse doctrine, it required a showing that the misuse of the patent impermissibly extended the scope of the IP right with anti-competitive effect. It notably found that effect lacking because it asked a pretty basic question. If you're asked to essentially purchase as part of a bundle some non-essential or unwanted patents, what is the foreclosure or exclusion? Well, by definition, if it was an unwanted or non-essential patent, you weren't necessarily going to go out in the market and look to buy one, so there's no competitor foreclosed. Now, I don't like two words in antitrust, which is always and never, but I do struggle as a general matter to understand under modern economics how, at an abstract level, package licensing is an antitrust problem in many, most, or even seldom cases. And it's worth, I emphasize, bearing in mind the transaction cost efficiencies, because I don't know, I'm sure many of us here have tough jobs, but one of the toughest jobs around might be being an IP portfolio manager for a large technology company. Maybe some of you here have that role. Trying to figure out exactly what you have and what it covers requires an army of patent lawyers, and even then you probably don't get it quite right. To try to figure out what's essential and non-essential, it's tremendously burdensome, and there might be a lot to be said for simply issuing a license, a covenant not to sue, essentially, that gives you patent peace, quote unquote. So when you look at that all together, I think as a general matter, I'm dubious that standing alone, that is likely to be an antitrust issue. Perhaps my co-panelists disagree, but I'd be surprised if you did.
Well, I wouldn't want to surprise you then, Alan. What you've said earlier about silly arguments reminded me, and what you just said as well, that I think I should get time and a half for listening to silly arguments. I have to do a good deal of the time. Well, similarly, there's been concern expressed in some quarters outside the U.S. in particular about a portfolio that may contain invalid patents or expired patents. And again, it's hard to see a problem, particularly with expired patents, where a portfolio is defined in a way that new patents are entering it during the time of the license and old patents are expiring out of it, and it would be completely impractical to price it on a daily basis, as it were. So that it seems like a complete non-issue as far as I'm concerned.
And to add to that, every patent portfolio of significant size has invalid patents. Just as a statistical matter, it's almost impossible for it not to be true. Just one of many studies found 46% of litigated patents to judgment, despite the presumption of patent validity, to be invalid. Now, there might be biases involved in that, but it's interesting nonetheless.
We've been talking about a very shadowy world, one that I don't see reflected anywhere else or imitated anywhere else, in which people are licensing patents and arguing about whether the royalty is friend or the offer is friend or the counter offer is friend, when nobody knows whether it's friend unless it goes to some sort of arbitration or tribunal. So it's very much, seems to me, very much like a market in unicorns. And then when you add in the question of uncertainty as to whether the patents are valid, it's a particularly peculiar dance that's going on.
Right.
I think if you look at it from the standpoint of the licensor and licensee, the two objectives meet there. The licensor wants to get full value for its patents, especially the ones that are standard essential. The patentee wants patent peace. But I've certainly heard clients say that when they are contributing patents to a standard, oftentimes they don't know what technology they have that reads on the standard and what doesn't. They have thousands of patents, and for them to actually do the exercise of figuring out every single patent that does and doesn't read on a particular standard is sometimes impossible, and by the time they finish that, the standard will already be out of date. And so for them to want to include ones they're certain are in the standard and ones they're not certain are in the standard is completely logical for them to get full value. And from the standpoint of the licensee, for them to want to license only those that are currently viewed as reading on the standard and taking the risk that others that aren't yet reading on the standard will be not something that they will still have to face doesn't make sense either. So again, I think this is presuming a problem that exists in almost none of the circumstances, but is oftentimes used as a tool, I think.
Well, I'm going to ask you in the U.S. So what I've heard internationally is that it's not fair. It's a black box. It's not fair to force someone to take something they don't want and they don't know what they're getting. And of course, in the U.S., under our Supreme Court has said forcing someone is not necessarily an antitrust issue, right? It doesn't harm. You have to have foreclosure in the tied product market. So can I ask you, what do you think of if the theory is that you're using the bundle to evade the FRAND commitment? Is that a U.S. antitrust issue, or do we really want to look at like monopoly leveraging and maintenance of market power as our sole theories?
Well, thank you for the question. Truthfully, I find it a little difficult to answer in the abstract because when we get divorced from the specifics of particular cases, it gets difficult. What I would say is there's a tension in the law which partially reflects kind of an impressionistic approach to competitive harm that characterized many decades past. So you have Supreme Court case law that I believe has yet to be overruled, and what Paramount Pictures and Lowe's, which talked about block booking in copyright being a form of misuse. So that remains tricky, and the Federal Circuit danced around it in 2005. Maybe for those who are newer to the antitrust game, who are perhaps more interested in sometimes in fairness than with, I suppose, economic analysis, which can seem a little cold and detached perhaps, something about the perceived coercion of purchasing patents or anything you don't want strikes them as problematic. But when we look at it in terms of price effects, market exclusion, I do have difficulty seeing it.
When I hear fairness, I'm in this situation, I'm reminded of a movie in which Mae West, and this was an ad lib on the set, when the other character said, another woman said about her jewelry, said, "Oh, my goodness, that set of pearls." She says, "Goodness had nothing to do with it."
But going back to the premise of your question, I think there was an assumption that had I not gotten these certain fraction of the patents, I would have paid less. But suppose actually that the facts are you would have paid the same, whether you have the non-SEPs or not in there. Then the question is, are you giving something away for free, right? I mean, you're not forcing someone to pay for it, right? So to go to the underlying, you actually have to say, well, this what the FRAND rate would have been had you separated the portfolio. And I mean, this goes back to the practicalities of, separating first what's a SEP, what's not a SEP, and the costs involved in that, doing it on a dynamic basis, that's really not practical. So
that is precisely what the Federal Circuit said in Phillips in 2005. So, sometimes the judiciary gets it right.
Sometimes the Federal Circuit gets it right, I think you mean.
So I hear a lot about the freedom to operate, right? And that, but it seems like the people who would be wanting this are the ones going and complaining to competition agencies and saying we don't want a bundle. So it seems like there's a little bit of any thoughts to that?
Well, sure. I mean, what they say doesn't reflect their interest. I mean, the concern is not necessarily getting the bundle unbundled. It's getting leverage over the licensor in order to get a lower royalty for the bundled package.
Exactly. It's not that they don't want the bundle; they want to pay less for it.
Right, they're just behaving rationally. I mean, just
Well,
to emphasize.
you're just using government in the negotiation.
Yeah, exactly as we'd expect. I mean, that's why as an enforcer, it's the tricky call you have to make is to distinguish claims that actually reflect the public interest and consumer welfare considerations as opposed to those purely of the firm itself complaining.
All right, well, in the interest of time, we're going to move on to our fourth topic, which is extra-jurisdictional remedies. Josh Wright mentioned this in his speech about the practice of some agencies, including the U.S. agencies and recently Korea, the Korea Fair Trade Commission, of imposing worldwide global remedies, including on foreign patents and foreign conduct. So, Judge Ginsburg, I'm going to turn it over to you to give your thoughts about extra-jurisdictional remedies and also what else you're seeing internationally.
Well, I think it was unfortunately, the FTC that got the ball rolling in this respect. I'm reminded of Bill Kovacic's remarks earlier about how these things come back at us. But it was in 2013 when the FTC got consent agreements from Google and for Motorola Mobility, and imposed the remedy. Well, their prohibition on seeking injunctive relief worldwide. Now that was a consent decree, and it was in a transaction in which this really wasn't an issue. It really just reflects the fact that the agency had leverage and was able to extract something that the firms were willing to give up. And now the KFTC has imposed a worldwide restraints on Qualcomm's enforcement of its global patent portfolio, all of which totally conflicts with any even basic notions of comedy, by essentially risking setting up a conflict in which a firm is either unable to comply with the laws of two jurisdictions, or more likely is deprived of its rights in a second jurisdiction. It doesn't have to violate the law, but it's unable to exercise its rights. And that may be because of the conflict in policy between the issuing jurisdiction and another. So if you take as an example, suppose that, I'd take on enforcement by injunction. It's still the law in the U.S., as Bill pointed out, or Josh, I forget who, that no court has said it was an antitrust violation to go into court and seek an injunction to enforce a patent, or likewise with the ITC, an exclusion order. But now, Qualcomm, or a company subject to this kind of a remedy imposed by another jurisdiction, is unable to do that. And if you think that the policy of the U.S. is, let's say, that we view these things as not anti-competitive, indeed pro-competitive, helpful to encouraging innovation, our policy is frustrated by a remedy imposed by another jurisdiction. And with what justification? Clearly, this is not going to affect the welfare of domestic consumers in, say, Korea, although it may affect the well-being of domestic manufacturers or implementers in Korea. So if it's some sort of disguised industrial policy, that's hardly a redeeming feature for it. Now, of course, where this has happened, the agencies deny that that's the rationale. Interestingly, both the European Commission, DG Comp, and the NDRC in China have very clearly limited their remedies to patents registered in their jurisdiction, and only with respect to licensing to parties in their jurisdiction, which is, it seems to me, exactly as it should be. There's really essentially no potential for conflict when that happens. But if this becomes a common phenomenon, it's going to be really chaotic and very much very unfortunate for competition and for consumer welfare.
As the sole FTC representative here, I should probably say something, which is that don't blame us, blame the old crew.
Yeah, you weren't there at the time, right?
Quite.
Exactly.
Our current acting chairman, Oldhausen, dissented in colourful terms in that particular matter. But to give fair voice to those who aren't here to defend themselves, I think what they'd say to you is that the goal in trying to prohibit injunctive relief overseas was to try to protect U.S. consumers in terms of imports. That's at least how it was explained to me. And if I recall, you can look at the order and check yourselves, and I should do the same, but if I recall the order properly, it didn't stop the respondent from seeking to enjoin an overseas infringer that wasn't subject to the jurisdiction of U.S. courts. So it wasn't quite the Microsoft Nokia reach, if I recall correctly. But what I would say is past practice is not necessarily, in this case, the best guide for the future. So watch this space.
That's a nice distinction. It was drawn in the case, but I think it was lost on our foreign counterparts.
I suspect that's true.
So I think, under U.S. law, traditionally, you look at a remedy. Well, first you have to look at the authority to enforce under the effects-based jurisdictional doctrines and FTAIA. And in every case, you'll see that a domestic injury is required for each and every remedy that's imposed. And there is no jurisdiction under either the FTAIA or effects jurisdiction to remedy what is purely a foreign effect. And that's true even under the standards imposed by LOTS, for example. So in addition to that, the domestic industry has to be direct, substantially, and reasonably foreseeable, which means it can't be remote. And it has to be, quote, tailored to fit the wrong, creating the occasion for the remedy. Now, the one thing I find particularly disturbing about the KFTC remedy in the Qualcomm case is that they impose a remedy and then they do something that's intended to look like it's bowing to comedy. The solution to effects that have both domestic and foreign effects is to think about comedy and which jurisdiction has the greater interest in enforcement or regulation over that issue. And the idea is to defer to the jurisdiction with greater interest. But what the KFTC does is they say, we're going to impose this worldwide remedy except to the extent that a foreign jurisdiction imposes a remedy that is in conflict with the remedy we impose here. Now, at first blush, you say, okay, well, that's giving some nod to foreign jurisdictions. But the one thing it doesn't allow for is it doesn't allow for a foreign jurisdiction to have a less restrictive approach. Essentially, it says only if a foreign jurisdiction takes action and only if it's in conflict with us, which essentially means it has to have a more restrictive approach in order for it to trigger this provision that's in the KFTC order, as I understand the translation. So I find that extremely troubling. I think it's way outside the bounds of any sort of FTAI-based authority, and certainly offensive to the concepts of comedy.
Alan, I thought your point was excellent. I hadn't thought about that. I don't think is that in the decision that they were worried about export, or that's just what?
I don't believe I said that. I said I believe the rationale.
The rationale, okay, because I think that's really important internationally, right? I mean, because my understanding is that foreign enforcers are worried more about their national champions, about their manufacturers, and it's a different thing to say I'm worried about my consumers and imports than to say I'm worried about, one is mainstream antitrust, one is not.
Quite, yeah. There's a world of difference, and what I'd add as well is that we should be awfully careful about extraterritorial reach in a world in which the interpretation and reach of economic analysis are not perfectly harmonious across countries. Let's leave it mildly at that. We don't want a situation where the first mover gets to set global law, right?
Anyone else on this topic? Any other thoughts? All right, well, we'll move on to injunctive relief. So, while U.S. courts have dismissed antitrust actions, we've talked about this today earlier on other panels, that there's been dismissals of antitrust actions on Norr-Pennington and on other grounds. The unfortunate thing is that following the FTC's negotiated consents in the Motorola Mobility and Google case and Bosch case, we saw a domino effect worldwide with foreign agencies, including in Japan and in Korea and Canada and in China, issuing draft or final guidelines that essentially adopt the approach and would create an antitrust sanction for seeking or enforcing injunctive relief. So, John, I'll start with you. What are your thoughts on these provisions, and what empirical or other evidence exists on the impact of injunctions on innovation? And I think you have a PowerPoint if we want to put that up.
Yeah, so I'm going to introduce an idea that occurred to me sitting in meetings like this and hearing a lot of talk about the need to protect and promote innovation, but then also hearing some people say that in case-specific contexts, where the innovation has already occurred, you can't measure the but-for effect on innovation. So it kind of gets dismissed in the ether that, well, since you can't measure it, we should just ignore it. And I started to think about that. Why can't you at least sometimes think about the impact on innovation? And I started thinking about it not from an antitrust or IP perspective, but really from an accounting perspective, which I have an unpracticed background in, and having spent a little time in-house. And I asked myself, is that right? Can you really not measure it? Or are there some circumstances in which you can? And so there's one circumstance I thought of where you might be able to measure it. This is a very simplistic concept. But the idea is that you sometimes can measure the impact of injunctions or the inability to seek injunctions on innovation. And my thesis is that the inability to seek injunctive relief has a measurable impact on innovation investment. And here are my assumptions. First, I assume that innovation investment decisions are based on some concept of return on investment. And that could be a formal or informal, explicit or implicit. So whether we're talking about a formal company process to get approval for the investment, or whether we're talking about someone deciding to take 3 years off and park themselves in their garage to come up with something, at the end of it, the concept is they're thinking about, gee, will I make a bunch of money on this? And that's the basis for making the investment. The second assumption is that there is some sort of target rate or hurdle rate. That's a very common concept for people who are in-house. You'll understand that very well. The third is that the inability to obtain an injunction results in a net delay in licensing. So we're really talking principally about time value of money here. And we could discuss and debate whether that happens, but certainly the proponents of preventing injunctive relief would argue that they don't want their feet held to the fire and have to sign up to a license before they've fully negotiated on what they think are fair terms. I've assumed that there's no change in the net licensing revenues here, so I'm dispensing with the whole concept of bargaining power, and I'm looking only at time. I'm also assuming that there could be an award of interest at the end of the day, so that if someone holds out, makes the inventor take them to court and get a judgment against them, the inventor might get an award of interest, and I take that concept into account in the later case. And finally, as we'll see, a very safe assumption that when you do the discounting and think about the time value of money, that the weighted average cost of capital exceeds the interest rate. And if you look at anything on the topic, you'll find that to be true. So here's the base case that I take. I take an investment, I put it all in year one because it fit well on the graph that way. I assume there's some delay because of an adoption period. You have to go out and actually get your patent. You've got to introduce it into the standard. You have to have the standard accepted. And then somewhere down the road, you start to be able to license that and get revenues. I assume the revenues increase, and then at some point they start to tail off. So that's the base model assumption. And if an injunction is possible, you could do a net present value calculation. If you add up the area of that triangle, the two triangles, and you compare them, in this particular case, you'd find an investment of 25, a total return of 80, but when you calculate the net present value of that, it comes out to 29.31. And that's at a 5% discount rate, which is a pretty standard discount rate. So that's a 17% return, 17.24. So if your hurdle rate was below 17%, you would say, okay, I'll make that investment. Pretty common standard approach to this. Now, if we take a case where an injunction is not possible, and we assume a 2-year delay, nothing else changes. The initial investment doesn't change, the total licensing revenues don't change. What we do see changing, of course, is the return on investment. And it's simply the relationship of time value of money. And in this particular case, you'd wind up with a net present value of the future revenue stream that is 24.26. And so simply because of that 2-year delay, you would say, gee, I'm not going to get my return on investment, and it doesn't matter what your hurdle rate is because this is a negative number, so you just wouldn't make that investment, all right? That's pretty standard. There's nothing very exciting about that. The only thing that I could think of, and I welcome comment on this, the only thing I could think of to offset this effect is the possibility of interest at the end of the day. Now, most cases, as we know, settle without litigation. I think someone this morning said 90% of the cases settle without litigation, and I think they were talking about an empirical number on that basis. And if we assume that the worst outcome for the implementer is a FRAND rate plus interest, we can sort of assess what that looks like. And if you look at the court cases, and I'm not an IP litigator, some of you can tell me I'm wrong, but commonly what you find is a prime rate or a T-bill rate, which is a very low rate. It's certainly lower than a rate at which most companies could borrow at. And it's certainly lower than your weighted average cost of capital, which balances your cost of equity and your cost of debt. And cost of equity is always higher than your cost of debt. And if you look at an NYU study out of the Stern School of Business, it will show you that technology companies have among the highest weighted average cost of capital in the industry. Why? Because there's more risk there. So the point is that even if you get an award of interest, there's always going to be a delta between your cost of capital for that time that you're carrying that investment and the interest award you get. And if you're even to take the average under the Stern School study, there's a 3% delta there, which is a pretty significant delta when you're talking about the impact of that on a net present value calculation. So my conclusion is that if there's an inability to seek an injunction and that results in a delay, that mere delay will cause some measurable impact on investment decisions, that those reductions of the return on investment will reduce innovation investments. I can't tell you what percent will get reduced, but some of them will clearly fall off the table because they don't meet the internal hurdle requirements. And that an award of interest is not going to be sufficient to offset that effect. So it's at least one instance I could think of where there is something that's measurable about the impact of delay on investment decisions.
I think you've conveyed something. I mean, I find that very interesting. I think you've communicated to me is what's an intuitive, strongly intuitive notion, which is that the stronger the property right over your innovation, the stronger your incentive will be to create it. And I think that's inherent in the nature of patent law when it comes to designing patent scope. I think there was that famous article, The Complex Economics of Patent Scope, in the Columbia Law Review. They went into this. There's always a trade-off, is the catch. So as patent scope gets broader, there's a greater incentive for pioneer invention, but it restricts the scope of cumulative innovation. So how well that works or not depends on transaction costs, which in turn depends on the industry involved. It gets quite complicated. Now, that captures something important that does get overlooked, I think. Sometimes it's too often taken for granted that the only issue is hold up as opposed to the opposite problem. As always, finding the exquisite balance is the hard part.
The whole idea that seeking an injunction could be an antitrust violation, at least in the U.S., is bizarre when one considers that if you have a right to the injunction, if you're going to have to prove in order to obtain that injunction, you're going to have to meet the standards for injunctive relief, probability of success on the merits, greater relative harm than would be incurred by the opposing party, and not contrary to the public interest. So if you can meet, it's not as if courts just issue injunctions just for the asking. Pay $15 and get an injunction. Sale today, $10. So if you have a right to an injunction, to say exercising that right is an antitrust violation is bizarre. And if you don't have a right to that injunction, you're not going to get it, and calling it an antitrust violation is just piling on for no good reason. So putting aside all the Pennington First Amendment type of objections, it strikes me as overlooking the fact that there is a process, there is a gatekeeper. You don't just get an injunction for the asking. Now, that's not so clearly true everywhere. I understand that in Germany, preliminary injunctions may be routinely issued, although I think security has to be posted. But at least in the U.S., it's perfectly clear that this is a a bizarre proposition.
I think there are a lot of nuanced points here that sometimes get overlooked in the larger debate. I completely agree that asking the government for an injunction in and of itself, divorced from everything else, is an antitrust problem. That doesn't really follow to me. It misunderstands antitrust. I understand antitrust as meaning we protect the competitive process. And what does that mean? It's the universe of market supply and demand side constraints that limit firm conduct and guide their future choices. We don't get involved because we dislike the effect of a business decision on market output in terms of price restrictions. That sometimes gets confused because we talk about consumer welfare. That is indeed the guiding lodestar of antitrust analysis, but that does not equate antitrust or potential antitrust liability and consumer injury as meaning the same thing. They may or may not be. That's why there's a difference between consumer protection and antitrust law. So what you often have here is the purported position that asking for an injunction necessarily endangers the market process afterwards. And there's a debate to be had. I personally don't find that convincing, and certainly not when there isn't an actual established market effect. But Judge, I'd be curious to know your take on this. Would you agree that it's possible that the pursuit of an injunction or the request for supra-competitive royalties, if there is such a thing, can perfect an antitrust violation that finds its source in some kind of separate behavior, such as deception of an SSO or even in the United States versus Singer in 1963, the Supreme Court essentially said it was a per se antitrust problem to pool competing patents amongst multiple rivals to use against a Japanese competitor. None of it was premised on that you successfully get an injunction and enforce valid patent rights. So there's a tricky relationship. I'd be curious to hear.
Is there a Cliff Notes version of that question? It's way above my pay grade.
Oh, not I doubt that very much.
Complicated.
Well, I don't think it's too complicated for you at all. I think the DC Circuit got it exactly right, and this is coming from an FTC person.
Rambus?
In Rambus. I think that caught now there are many in the FTC who disagree with that decision, and you won't be surprised to hear, but I thought it captured something important. Well, the DC Circuit gets to decide, but I just happen to agree because it focused on the elimination of a competitive constraint in an upstream technology licensing market, that if you had a proprietary technology that was essential, regardless of whether it was disclosed or not disclosed, or FRAND encumbered or not RAND encumbered, any pursuant harm would be at most essentially a breach of contract, not one that finds its source in the elimination of a competitive constraint. It's that subtlety that I often find missing from this debate.
And Alan, can you, for the non-antitrust lawyers, talk about 9X a little bit and what this means, the competitive process and the unlawful acquisition, the but-for causation?
Oh boy, this is a hard one. I saw a couple of my students from Georgetown here last semester, and we spent a bit of time talking about this. It's not easy to capture, and yet it's so very fundamental to what we do as antitrust lawyers. There's some debate about whether the DC Circuit was true to 9X or not. I'm not sure it's actually the best vehicle to try to capture the point. When we think about your ability to, well, let's think of it this way. Think of it in terms of monopolist. U.S. antitrust law does not prohibit monopoly prices, even if they're extortionate and horrible. That makes us something of an outlier in the international area. But the reason we don't do that is because we're not price regulators. When you go after high prices, for example, what you're doing is you're going after a market outcome, and we're not asking what the source of that market outcome is. If the source of that market outcome is the lifting or evaporation of a competitive constraint, for example, you colluded with your rival, or you employed a field of unilateral behavior that excluded an equally or more efficient rival, well, then we're concerned. And one might ask, if we're concerned with protecting consumers, why do we make it so complicated? Well, the answer is we tread on precarious ground when we jump past the market process on which U.S. antitrust law is firmly based. And I think it's important to acknowledge that. U.S. antitrust law believes in the power of a free market, freed of artificial restraints and exclusion, to produce good outcomes. When that process breaks down, and sometimes it does, that's when we regulate. But we don't use U.S. antitrust laws to try to regulate market outcomes. That's why we focus on competitive constraints. And in the SEP space, there's a big difference between deceiving an SSO into adopting your technology over an equally effective proprietary alternative, and simply just taking a patent that's standard essential and asking for an injunction. Not surprisingly, this nuance gets lost, but I think it's fundamental to understanding this area and antitrust generally.
as a follow-up, I hear this a lot that, well, SEPs are different, right? We allow competitors to get in a room and pick winners, and we normally wouldn't allow that, right? Normally that would be, the Supreme Court says, collusion is the supreme evil of antitrust. But because of the benefits of standard setting, because there's so many benefits to standard setting, we're going to allow this. But then there's sort of an idea that, but then later we're going to apply a sort of different rule with unilateral conduct. So what are your thoughts on this idea? Are we there? I know there's not a lot of empirics, but there's one paper by Elaine Farrar and Padilla showing that maybe instead of standard setting process picking winners, it's actually crowning existing winners. Any thoughts from the panel on this sort of fundamental kind of driving the intervention in antitrust?
Well, maybe not to that point, but I've always found it curious that when you talk about the availability of exclusion orders or injunctions, no one ever talks about whether there's actually harm to competition from that. So if a consumer has, is there an effect on the consumer if they have 19 handset choices instead of 20? It's not a question we ask. It's almost an automatic assumption that the injunction itself, the seeking the injunction itself, is an anti-competitive act. But normally you look for some exclusionary effect and for some harm to consumers.
Right. It raises an interesting hypothetical. So if you had the pursuit of injunctive relief over using an essential patent for and encumbered for which there was no technology or technological alternative ex ante, one of the crowned winners, I agree absolutely with you that the simple narrative, this is sometimes when we fall in love with theory too much and it gets divorced from the real world. We have to be careful about that. But we just presume that it'll harm. Well, maybe, but as Chairman Olhausen pointed out in dissent in Google MMI, maybe not. We're ousting the courts, and the ITC and federal judiciary are well placed to try to figure this out. Different issues overseas sometimes, but yeah. But suppose we had a case where the use of that injunction actually successfully resulted in a monopoly in a product market downstream. That is an interesting question. But for me, I'm still not sure about that because I look for the antitrust violation upstream. I ask what unleashes the power that caused harm. And if it's just breaking a contract, that seems like a contractual issue. If it's eliminating a competitive alternative that gives you this extra power through deception, etc., then maybe we have an antitrust case. So there is a role for antitrust. I just want to be true to what antitrust is and is not.
So hi, this is Jorge. I think that there is an interesting dimension that the panel may consider, which is whether there is a difference in what you're saying depending on whether the company that seeks injunctive relief is a non-practicing entity or it is a vertically integrated company that operates in the downstream market. Because it may be that in the second case, you may have that the seeking the injunctive relief actually leads to exclusion and monopolization. Now, I would like to hear your opinions on that, but at the same time, I would also like to hear from you, why is it that if that is the case, that if the difference is sort of negative for the vertically integrated company, however, those that are requesting or advancing arguments against injunctive relief immediately add or append to that request that prohibition is restricted to non-practicing entities?
I just, if you don't mind, I'll jump off very briefly, which is to go back to 9X. At the Second Circuit below, they observed, and I think the quote is, it is axiomatic that a firm cannot monopolize a market in which it does not compete. So if you're talking about an NPE, it seems to me that by definition it cannot monopolize a downstream product market, even if it excluded everyone from practicing in it. Potentially it could violate antitrust law in an upstream technology licensing market, and that's a distinct question that I didn't understand you to be getting to. But I would say in the post-eBay world, it's extremely difficult for an NPE or various versions of NPEs to get injunctive relief. I don't know if anyone here disagrees with me on that. Because where's your irreparable harm if you were practicing the technology? I think that's the challenge. And if that's true, and if that's effective, then maybe that's part of how we see non-antitrust factors actually solving the problem, if only in part.
You'd almost surely have to show that the defendant is not good for the money.
Yeah, I'd say in practice you'd have to do that. Yeah.
Now the European Court of Justice in Huawei against ZTE lays out a framework which, if you're going to ever going to have the possibility of seeking an injunction being a violation, I think it's a very sensible framework. and at that critical point, it requires that the defendant post collateral.
I mean, usually when I was at the FTC, the theory of harm for injunctive relief was that you're using injunctive relief as leverage to obtain higher prices than you could have obtained otherwise. To me, that's just excessive pricing. That's not what we do in the U.S. So if it's somehow that there's, more complicated theory of harm, I guess I go back to what's the theory of harm, and is it antitrust, which is about unlawful acquisition or maintenance in market power, or is it really just complaints about price, which we don't do, at least we're not supposed to in the U.S.?
I think it gets, to Jorge's point, it gets a little confused in some jurisdictions and maybe some people's minds that the higher price resulting from either the threat or the actuality of the injunction may result in there may be contract damages. Let's put it that way. If there's no injunction, there may be contract damages, but the damages will not compensate the consumers. Right? They're collateral damage while this is sorted out.
So according to the time, we have about 7 minutes left. So more questions? Yes.
Thanks, Corin. Relating to what you were saying earlier about standard setting, one of the points to emerge earlier today at the panel that included the standards organizations is that standard setting is a misnomer. It's standards development, that it's engineers coming from all over the industry, those who build the devices, those who invent the technologies, and figuring out the best technical solution to a problem. So the development really more than setting, they're not sitting in a room picking a winner. And I'm wondering what the panel thinks about how this, thinking about it in that respect, how that will affect things legally downstream.
So it's the issue which we've heard a long time, that certain people want you to say SDO and other people SSO. I do think it's different, right? I mean, where there's a setting implies sort of that it's about the size of the plug and you're just sort of setting a standard. And development, I think, I agree, probably more accurately describes what's really happening. But do you see that having a legal effect? Is that the question that does? The
way we think about these things can
Yeah.
be happening in real life affects how they are perceived.
I mean, there's just a debate about it happening like that. I mean, I agree that I've never been in the room. The engineers I've talked to have described to me that it's a development process. I have heard implementers say that, no, it's a picking winners. And then when I asked, well, what's the evidence? I was told it's confidential. I can't tell you. So, but that the engineers I've talked to have described it as development.
I think it's important for antitrust analysis that it be true to the facts. I worry about the power of narrative sometimes, as I alluded to, influencing or colouring the analysis brought to bear on the problem. But I think done properly, understanding how the standard setting process works, one can appreciate the proper role for antitrust and also for contract law.
So your question was about, the legal ramifications. I'm a little hesitant to actually say anything, but since we had the lawyer put up the model instead of the economist, let me say, I think it actually goes back to the model and to the calculations that we had before. Anything that would happen later will change the incentives to invest. I mean, here was a very simple model of investment, but you could actually imagine, deliberately, simple to make the point, but you could imagine that whatever is going to happen later down the road is going to impact what happens in those discussions, right? Whether they're developing a winner, choosing a winner, or just pure out developing new technology, whatever the title is, whatever actually happens, you could imagine the incentives are going to change depending on what happens down the road, right? So that's not the legal answer, but that's, I think, the economics of it.
It's always been an interest of mine because some disputes in this space are probably inevitable because of the manner in which STOs or SSOs choose to collaborate on standards and bring them together. That's not a criticism, it's just an observation. STOs are quite properly concerned with advancing the best technologies and getting down to business. They don't want to turn it into a lawyer's affair, let alone a commercial negotiation. But if SSOs or STOs were to hammer out specific price terms, you wouldn't have this subsequent debate. But anytime you have a situation of sequential contractual performance, which exists in the SSDO negotiation process and afterwards during implementation with IP holders, you're inevitably going to have some kind of strategic behavior, but it occurs on both sides, both promisors and promisees. And sometimes I wonder that the hold-up narrative, although I do emphasize, I believe it can apply in the real world. I just don't think you say the words and it's necessarily true. But I sometimes worry that it's captured some kind of outsized attention to the deficit of other problems too.
I think from an antitrust legal standpoint, it's interesting that most of the debate and discussion has not been around the joint conduct during the standard setting or development. It's been around the unilateral conduct in terms of the implementation of licensing policy. Although if you look back at the initial cases, they were centered around fraud at that stage. So the cases have probably been more at that stage than elsewhere, but the discussion and debate has all been at the licensing end, which tells you that when it comes down to it, it's mostly about money.
Yes.
So I think that coming back to the SSO versus SDO, I think that that is, at least as a matter of economics, more than mere semantics. I mean, if you think about all those contributions in the economics literature that talked about ex-ante pricing, incremental value over the next best alternative, and so on and so forth, or even more recently, the work of George Lerner and Jean Tirole talking about ex-ante price commitments, that all those pricing models, all those models fit neatly within the SSO view of the world, but don't make any sense with the SDO view of the world. In the SDO view of the world, there is no ex-ante, really, because the technology is developed by collaboratively within the standard. There is no elimination through the standard selection process of competition and creation of market power. So in my opinion, I think that has, I see that Aviv disagrees, but I, in my opinion, that has fundamental implications in terms of how we price and what we define as friend.
Yes.
You want me to take that, or?
Oh, I'm sorry. Yes, go ahead.
So, I mean, at a broad level, well, I agree and disagree at the same time, if that's possible.
It is with lawyers.
Okay, good. I mean, I see your point that it does, once you go into the details, it matters. I mean, I kind of kept it at a high level of saying it's about the incentives, and there will be a change in incentives depending on what happens downstream. I think you have to be a little bit careful when you take any economic model, or any model like what we just saw earlier, to take it too literally. It's just supposed to demonstrate a point. And I could imagine if you're thinking at the standard developing setting, right, instead of a standard setting, sorry, no, too many settings there. But in those two situations, you would actually think of it about a little bit differently, and rather than think about the ex ante and ex post, I think you might want to think about the but-for world of what would have happened without this standard developing setting, what would have happened. And, sometimes we take a too narrow of a view of what the ex ante world is, just saying, oh, well, if it weren't this alternative, we would have gone to the next alternative, instead of thinking what would have been the kind of the more holistic negotiation process that would have happened in the but-for world. So I think that kind of general idea does generalize. Now, maybe, particular results from one particular paper, those are not generalized, but now we're talking a little bit too much in the weeds. So I'm not sure if that's agreeing or disagreeing with you, but I do think in the sense that kind of a general idea that what's going to happen down the road, whether it's injunction relief or any sort of outcome, is going to matter for the incentives that happen at that, that initial stage, whether it's setting, developing, or whatever it is.
So I'm sorry to those we didn't get to for questions, but that's all the time we have. And I want to turn it back over to Mark and thank our panelists so much for a wonderful panel.
Thank you to all the panelists, and thank you to all the folks that have come to attend the conference today. I hope that you found it to be interesting and informative. I especially want to thank all of the speakers, all the panelists, for the time that they put into their presentations and getting up to speed on some of the various areas that came up in the discussion and in the questions. I know from personal experience it's not easy to do that, especially when you have a normal workload that you have to attend to. So thank you very much for that, and also for the moderators who probably do an even extra amount of work on top of that, because they have to meet with their panelists and talk about the various questions that they're going to ask and the discussion topics. So again, very much appreciate that. I wanted to point out again that CPI Antitrust Chronicle is going to have a special edition coming out that will feature the conference proceedings. And lastly, or almost second to last, I'd like to thank our sponsors for the gracious support they provided to making this event possible. And there are several people that have worked very hard to bring this event to you. Kirti Gupta, of course, I mentioned earlier in my introduction, but also Isabel Wallace, Jenna Shrove, and Christine Spies have been working behind the scenes to make sure all of the arrangements and everything were put together, so I'd like to do a little shout out to them and thank them.